Well, good to see you all this morning. And I am Chuck Dunlap, directly somewhat south of you in Indianapolis. I'm executive director of the Indiana Bar Foundation. And I also am an adjunct professor at Indiana University. So happy to see you this morning, and I'll let my other two colleagues introduce themselves.
Good morning, Michigan. My name is Caitlin Johnston. I am a Hoosier as well. So I did We the People in Indiana when I was in high school, though I never made it to nationals. And now I'm joining you from my little studio in New York City. And my day job is I'm an in-house attorney at a fitness company called Peloton.
And good morning. Michigan, congratulations on being here at the national finals, even if virtually. My name's Andy Levy. I'm a trial lawyer from Baltimore. I also teach at both of Maryland's two law schools. And I'm joining you from a little town called Highland, which is about halfway between Baltimore and Washington, D.C.
Great. Would you introduce yourselves to us and your teacher?
Thank you for allowing us to testify before you today. We are the Black River We the People team from Holland, Michigan, and we represent Michigan's Unit 5. My name is Sia Rajguria. I'm a junior, and I'm on Units 5 and 4.
My name is Ariana Newberry. I'm a junior, and I'm on Units 5 and 2.
My name is Anya Osmani. I'm a junior, and I'm on Units 5 and 3. And our coach is Peter Letzman, assisted by Luke Ryder.
Wonderful. Well, thank you very much. Let's go ahead and get started. And again, I know you know the question, but it's Unit 5, Question 2. I'll go ahead and read it and we'll get started. Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? And to what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses? You may begin.
In 2018, Timothy Verrill was charged with 2 counts of first-degree murder. A judge ordered Amazon to hand over audio recordings covertly stored by an Echo device containing incriminating evidence. Today, our smart devices open up more data to law enforcement than ever before, but at a cost.
Individual privacy is in jeopardy at the hands of tech companies who have a profit incentive to collect user data. When terms and conditions are agreed to, the government often has access to this data through the third-party doctrine, as established in U.S. v. Miller.
Furthermore, private corporations are not bound to the Fourth Amendment, giving them free rein to spy on users. The rising social media platform TikTok is partially owned by the Chinese government and collects mass amounts of personal data, causing the app to be banned on all federal devices.
The government has been willing to violate personal privacy in the name of defense. After 9/11, Congress swiftly passed and continued to renew the highly intrusive Patriot Act, curtailing American liberty.
This gave the NSA unprecedented power to surveil. Using secret FISA courts, where only 85 out of 40,000 warrant requests have been denied, intelligence agencies have access to roving wiretaps, which allow a single warrant to cover as many devices as they want, coupled with sneak and peek warrants, which let authorities conduct searches without notifying the target.
The Fourth Amendment is meant to protect individuals against unreasonable searches and seizures like these, as established in cases like Katz, Kyllo, and Carpenter v. US. However, modern, rapidly changing technology makes these cases difficult to apply in a world where everything is shared.
We agree with Richard Posner that the American public worries more about invasions of personal privacy than other government curtailments of liberty. But they willingly surrender this privacy for the sake of convenience.
As the court held in Carpenter, cell phones are indispensable to participation in modern society. For most Americans, the balancing act between privacy and a technologically enhanced quality of life is a no-brainer. Individuals still choose to use these devices, despite understanding the sacrifice they are making.
And while the method of Verrill's conviction in the Amazon Echo case raised some eyebrows, Americans still rush to the store to buy smart home devices. Companies are making billions off of our personal information, and the industry of selling data is now worth more than oil.
But Americans' willingness to give up privacy for convenience should not be abused by companies. Americans need practical protections now, and the reactive courts are ill-equipped to deal with modern technology. As Justice Alito stated in Riley v. California, it would be very unfortunate if privacy protections were left primarily to the courts. Legislatures elected by the people are in a much better position than we are to assess and respond.
Some states like California and New York have taken steps to better protect their citizens from corporations, passing laws inspired by the EU's General Data Protection Regulations. Companies are required to disclose what data is collected and sold, while also allowing users to remain anonymous and revoke their information at any time.
The federal government needs to follow in the footsteps of the EU. But until this happens, private companies have intervened to create practical and accessible avenues for protection online. For example, software like the Tor project or VPNs can conceal a user's location and usage data.
Corporations, not our democratic institutions, are the ones leading the way on privacy. But relying on either of these entities to protect your privacy is like relying on a fox to protect your henhouse. Thank you. We are now ready for your questions.
Great, thank you very much. I wanted to talk a little bit about our current situation with COVID-19, et cetera, and how courts should handle the analysis of, the idea of contact tracing and government for the public good and for public health concerns wants to sort of and needs to potentially get some of our private information, contact tracing, tracking movements, things like that in the name of public safety, and also balancing individual privacy rights. How should the courts analyze this particular situation, and are there any precedents that have existed before for them to help guide them?
Well, I first think we should look at how prime this would be for abuse. We see that projects HT-Lingual and Project Minoright from the NSA in 1952 allowed for our government to look into international communications. However, the Church Committee exposed the bad practices of these projects, and we see that allowing the government to look into international communications only led to them going into into domestic communications as well.
And furthermore, what Ariana's point, I think it's also, to answer the second part of your question, I think if we look to the courts and what precedent has set, I think courts will have to look at whether this actually defines as a search. Under Katz v. US, it would have to look at whether we have a reasonable expectation of privacy to this today. And I think furthermore, courts should look at the ruling in Kylo v. US to see whether this technology is accessible to the general public.
I'm sorry, so what's the answer to that? Using the reasonable expectation of privacy standard, do we?
I would argue that under the reasonable expectation of privacy standard, that we do have a reasonable expectation of privacy to who we've been in contact with and who, and our own.
But is that reasonable? Given all we know about what companies do, is it a genuinely reasonable expectation?
I believe that individuals do have a reasonable expectation of privacy to an extent. However, the third-party doctrine does allow, as established in Smith v. Maryland, for private companies to have access to most of our data and share that with the government. But I feel that that argument is not valid to say that we have no reasonable expectation of privacy anymore today.
And
So if you turn on location services with your iPhone and Apple decides to share the location data with local police so that they can go and ticket anybody who's not honoring the 6-foot social distancing rules in the name of kind of controlling COVID, is this panel okay with that? How would you analyze that, the legality of that?
Well, first, I think we have to look at the fact that it's location data. This data, since it's collected through your phone, is encyclopedic detailed and effortlessly compiled. And this data is not allowed to be used without a warrant, as seen in Smith v. Maryland.
And furthermore, going off Ariana's and Anya's earlier point, we see that in Carpenter v. US, where the standard was defined, it was ruled that cell phone metadata could not be collected and used without a warrant, especially could not be collected and used without a warrant.
So what if Apple, or let's change it to Instagram. So what if Instagram implements a process without the government to just say, if you have the app open, the person across the street who's also using Instagram, it can tell you whether he or she has tested positive for COVID-19.
I think we also have to look at the terms and conditions that you agree to when you sign on to using these apps. If individuals accept that this data should be able to be collected, they have in effect given up their right to privacy in this way.
Should the government protect us from that?
I would argue that 100% they should protect us from these abuses of power. We see the national government hasn't been stepping in, but many states have been stepping in. We see states, especially like California, have stepped up, and they've created a California Consumer Protection Act, which allows, which makes companies disclose what information is being what data is being taken from users in a reasonable and accessible and understandable way. I think this is really important to look at, because we see with terms and conditions, they're almost impossible for any general user to sit down and read them and understand them without a lawyer present.
And we also see that with the Cambridge Analytica scandal, 87 million Facebook users' data was taken and used for election and campaign advertisements. And this is really important, where we see that there's a need to protect this online data.
So outside of California, no protection though?
We see many states, other states like Illinois and Washington and Texas have done this, but it's still a select few number of states. I definitely see the need for the national government to step in and enforce this at a national level to ensure that every state, every individual has these protections to prevent against these large companies abusing their powers.
We can see countries like Europe have done this. Countries in Europe have done this, like the UK, who have implemented the GDPR.
And this is because the culture in the UK is where people are more afraid of companies taking their data rather than the government. And here I think it's the other way around, but I think there should be a good balance between both protections from government and from companies taking our data.
And furthermore, kind of going off of Ariana's point, I think one of the issues that we see today is that people are not aware, nor do they really care. They might care in theory, but may I please finish my statement?
Please.
A study done by Pew Research shows that 81% of Americans are concerned about the way that businesses and governments are using their data, but only 25% have actually changed the way that they use technology. Thank you.
Thank you very much. Very nice job. Enjoyed it thoroughly. My virtual thumbs up there. So just a little bit of feedback from us. I'll go ahead and start. Let's see, I wrote down a lot of things. The comprehensiveness I thought was really good in your opening remarks and your opening comments. A lot of really good examples. And it's interesting, the idea of, you know, the corporate versus the government aspect and the relationship between the two. And, you know, the constitutional structure obviously is limiting the government action, but so much now are the private providers, and the relationship again between government and private industry getting information. And the idea too that, you know, that we spend some time on is government's there to help us, help protect us. And sometimes information is necessary to do that, but there's always a trade-off. And I thought you explored that well, and you had a lot of really good in-depth analysis of a lot of these issues that are not easy. None of them are easy, which is why it's so much fun to talk about. But I thought you did a really nice job, and I enjoyed it immensely. Thank you.
I agree. Bravo. That was a great presentation. It sounds like you're acknowledging this issue that in my profession we know to be true, which is people say they care a lot about privacy, but they still want access to all of the social media platforms. And guess what? They're free. How do those social media platforms make money? They sell advertising that's highly personalized, which is based on our data, right? So there's a very real kind of macro societal how to deal with that. I liked the CIU sneaking that stat in at the end. I think that illustrates it perfectly. One just minor comment on your prepared remarks. I know you're bound to to only 4 minutes, which is super tough. I would have loved to have heard a little bit more analysis on that case that you led with, the Alexa case. I think it's a really interesting one, and you can tie it back to the constitutional principles. And it was very attention grabbing, which is obviously that was your goal. And I liked how you circled back to it at the end. We could have talked about that in the follow-ups. Same with your TikTok comment. I thought that was really, really interesting. So very, very thought-provoking, both in the prepared remarks and in the follow-up. Great job.
So yeah, no, I definitely agree with what both Caitlin and Chuck have said. That was a really interesting opening. Yeah, you really got my attention with the Alexa example. And it's, you know, cases like that really, you know, those are the hard cases, because there is sort of, if there's not a compelling interest in solving a murder and holding someone accountable for a murder, you know, what is? I'm sorry, I felt a little bad. I busted your chops about the reasonable expectation of privacy, though I thought you responded well. And Anya, you had a good answer too. It's always been an interest, that doctrine's always been very interesting to me because of its sort of artificiality. I mean, it is law that we have no reasonable expectation of privacy in the contents of our trash once we put it out on the curb, which, if you think about, is an absurd notion. I mean, all you got to do is, if your neighbor started pawing through your trash, you know, how would you feel? Like, really, I have no reasonable expectation of privacy in that. So it's like many constitutional doctrines, there's an artificiality to it. And when you are, when you're considering questions like this, you have to be careful to not use sort of a common sense necessarily understanding of what that might mean, but the sort of the almost the term of art use in terms of the way courts have interpreted it. And I thought sort of you guys did a really sort of excellent job in doing all that. So, you know, I agree. Bravo to all of you.
Thank you.
Thank you.
Thank you.